My name is Kate Brady. I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America, and I welcome you to this webinar today. We're going to be talking about adjustment of status, which is lawful permanent residence from inside the United States. This is really one of my favorite applications with the government. I know that's kind of odd to say, but I think that it is one that I have seen change so many lives for the better. I know that we're going to give you some information here that's going to be exciting and helpful, and hopefully I can tell you a little bit about the application generally, and then some of the pitfalls that we see here at CLCMA where cases are caught up in the system and where we get involved, and then also give you a little peek behind the curtain of what CLCMA does. I'm really excited to talk to you about this one, so let's get started. So lawful permanent residency is an application to permanently reside in the United States to work and be here long term. There's many different avenues that you can get here, and those are very vast, including through your relatives, through your employment, through the diversity visa, through asylee and refugee, and through some of these other special immigration programs. I would say that I see it less often in the diversity visa because most people are coming in from outside, but it is still possible to be here in the US, maintaining status, and get that application and be an adjustment of status. And also the investment visa, although it's a very high threshold, a lot of people again are outside of the United States when they do this, but it is possible to maintain status in the US, make that investment, and then switch over to permanent residence through that program. We're going to talk probably more about the basic parts of the program and not some of those special programs, and hopefully give you some insight, especially into marriage-based applications, and answer some of those questions that you might be wondering about. What happens if you want to have a spouse who's here in the United States or can get here to the United States, and what can they do? But we're going to talk a little bit generally as well. So foreign nationals who are in the United States who have been inspected, meaning they came through the port of entry, CBP actually saw them, made a determination to let them into the country, those are the ones who are eligible for adjustment of status. They will have gotten an I-94 arrival departure card upon coming into the United States, and they will have a petitioning relative or employer, or in some of those instances qualify as a self-petitioner. If you are as a spouse of a United States citizen, or a child under 21 of a US citizen, or a parent of a US citizen, and you are here lawfully, if that US citizen child is 21, then you can actually simultaneously apply for your immigrant visa and for your adjustment of status. You cannot be under an order of deportation, and some people do have other situations where they will need to maybe have a waiver of inadmissibility for certain things that make them ineligible, but not permanently ineligible. Those things can be waived. This is not an application that is available to most people who entered without inspection. There's some very narrow exceptions that we're not going to get into. Most of those have expired by this point, and so we're just going to go with the basics. If you are in a category that is limited annually, you will need to wait to file your adjustment of status until your visa number is available, which we'll talk about just a little bit here. So the application is called an immigrant visa petition. It's the same application that is done for people who are outside the United States who have either employment or a relative, or like I said, that investment, that they will be able to start the process of getting that consular appointment abroad. And it sets the priority date. And a priority date is important when we talk about availability in those limited categories, because that is kind of your ticket in line. And as you look at the visas, what we're looking at is the fact that there are only 226 family-based visas annually and 140,000 employment-based visas across all the countries and all the categories. So those lines can move really slow in the limited categories. And certain countries are very high demand. We call them oversubscribed. And if you look at that chart on the bottom, China, India, Mexico, and the Philippines are broken out because compared to the rest of the world in all chargeability, they have more applicants per category. And in some of those categories, you can see that they might match up, but not in every one of them. There are country and category limits in each of those areas, which means a certain percentage can be in those categories before you have to basically stop the line again. There's a cool concept here that I've listed called cross-chargeability, and that means if you are in one of those oversubscribed countries, whether it's in the family-based or the employment-based, but you have a spouse who is in another country who is all chargeability. Let's say you are from Mexico, but your spouse is from Brazil. You can actually move over and be in the all chargeability category. It doesn't always work out better, but sometimes it does. The other category that we talk about is immediate relative. Those are US citizens who have a spouse, a child under 21, or a parent they're applying for. Immediate relatives are not out of these 226,000. They are actually unlimited. So as many immediate relatives as want to can apply in a year. They still have to go through the processing time, but they do not have to worry about whether a visa is available. It's immediately available. That's what that means. So there we go. Either the visa is available or you're an immediate relative and you can move from your I-130 or your I-140, your I-526 onto your I-45 for permanent residence. As part of the application, you need to get a medical exam at an approved physician, and I'm not sure why they call it this, but they're called a civil surgeon. I promise you there is no surgery, but there is how you find them. They're specific. You cannot just go to your own doctor, fill out a form. It will be placed in an envelope that is sealed and handed back to you, that is mailed in with your application. If you do not mail that in, you will have to bring that in with you at the time of your appointment. Or there may be a request for evidence for you to mail it in later. While your case is pending, you are eligible for 2 additional applications, one for employment and one for travel. Those are available to you because your case is pending. Once your case is decided, either approved or denied, those things go away. Almost immediately after you make your application, you will get receipt notices. You will also get a notice to come to the Application Support Center. The only thing that is done at the Application Support Center is your biometrics. And what that means is your fingerprints and your photo. And that'll be part of your background check. Adjustment of status processing time varies somewhat based on location because the demand is different. So if you're making an application in somewhere like New York City or Atlanta or Dallas that has a lot of people applying, you may spend a long time waiting, whereas somebody who is in a smaller locale, let's say somewhere like Wyoming, they may not wait nearly as long. But right now, a lot of people are waiting a long time, longer than a year, which is unfortunate. 4 or 5 years ago, we could have said, especially with an immediate relative application, within 6 months, you would likely have your green card. That is no longer the case, even for an immediate relative. Almost all applicants are required to appear for an interview. The most common one I see now that does not is usually a parent of an adult US citizen. They are most often waived. It used to be that employment-based applications were also waived, but in 2017, this administration took out that general waiver. So now that has even more so slowed down the interview process for everyone else, because we have now laid on all of those adjustment of status applicants who used to not have to go in for an interview. They are now in the interview queue. So let's talk about that interview. It's generally not something to be worried and scared about, but that is not always the case. As we have seen in our cases, there are a lot of people who have an interview that lasts a very long time or has very unusual questions, and most often those happen even without an attorney. So I always say that if you think there's a problem with your case, please do think about getting an attorney. This is an administrative interview, though. It is not in court. And that interview is going to review your application and confirm your eligibility. If you're employment-based, they're maybe going to ask for your pay stubs and see if you're still working for that employer, or if you've made a change in your employer, if it was an authorized change. And if you're doing it based on a relative, can they see that you are actually related to that person as a spouse by marriage, or as maybe as even a sibling by birth to the same parent? And that's something that they're going to do at that interview. Married couples are almost always interviewed together if it is a marriage-based petition, and that only is a problem if there is suspected fraud. And at that point, they may be separated, asked very detailed questions. Sometimes even it will be taped. And even sometimes on interviews that are not marriage interviews, there will be a video done. An attorney can always be present if they are the attorney of record on your case. You can have a translator attend, and they do not want it to be the attorney or your spouse. USCIS will also not provide that translator. And you should always bring original documents of the copies that were submitted, because an officer has the right to look at those originals to make sure that they match up with the copies that you provided, that they are authentic and true and correct. So sometimes things go well and sometimes things don't. And so let's talk a little bit about what can happen. The one that we would always hope happen, you're granted. You're going to get a form letter that comes on that same kind of odd government paper that's called a welcome letter, and you will have your resident card mailed to you. They could ask for more evidence. That may be because something changed in the law, or they weren't really sure of your marriage and they want to see more. You could have additional interviews. This is one that nobody likes to hear, because it means that they weren't convinced at the first interview. A one and done is what we always like to see, but sometimes there are additional interviews. And in many of the cases that we have, we see that those additional interviews can go very long, hours and hours. And this is really where we see things turn to a point where there may be that national security concern, which is part of our scope of our services. And we may take a good look at your case if you think that there's been some discrimination. They could issue a notice of intent to deny. That's usually for more documents and maybe a legal argument. They could also issue a denial, which you can fight with a motion to reopen or reconsider, but that goes right back to USCIS. Or you could be referred to immigration court after the denial, and then you can defend before a judge. Sometimes that's the best thing, because a judge may have an easier opportunity to see the evidence that's laid out in testimony than what a USCIS administrative officer did. So even though this sounds scary, sometimes it is the right way to go, and sometimes it is the only way to get into federal litigation, because through immigration court, then through the Board of Immigration Appeals, you can then go on to federal litigation, which sometimes is not possible if you are only going through the administrative process. After you are denied, you may want to go to the Board of Immigration Appeals from the court. From there, you would need to go to federal litigation if you still want to fight it. The applications that are done for marriage, where the marriage has been in place fewer than 2 years, will result in a conditional residence. This is for everybody who's been married less than 2 years at the time of their application. Sometimes you will see an officer who, when you get to the interview, if the marriage has been going on for longer than 2 years, they may not issue a conditional card, but in this administration, I've almost always seen that you are still going to get a conditional card. And that means that at the end of that 2 years, 90 days beforehand, a window will open up where you are required to submit a petition called an application to, or a petition to remove conditions. And what happens there is you are going to submit additional evidence, and hopefully it is signed by both of you because you are still married and not separated. And that application will be seen as kind of an update to the original I-130, showing that you are lawfully married and it's not a fraudulent marriage. This is really the mechanism that they're using to catch people who entered into a marriage where it was only for the purpose of obtaining that immigration benefit. If, however, things didn't work out in the marriage, all is not lost. There is an opportunity to do a waiver, and that is done if there is divorce or separation, or if you're widowed, because there is good faith or an extreme hardship if you are not granted that waiver. If your removal of conditions petition is approved, that means you will get a 10-year card. The interesting thing is that these are taking a long time. So you make this application within that 90-day window between 1 year and 9 months and the 2 years when your card expires. There are some exceptions where you can apply afterwards, but really you need to try and hit that 90-day window. You can't go before, and you really shouldn't go after. And if it pends, as long as it has been recently, which is sometimes 18 months to 2 years, you are going to possibly be eligible for citizenship if you are still married and living with that same U.S. citizen, because that only requires 3 years as lawful permanent resident, including the time that you've been a conditional resident. So you may choose to file even though your petition to remove conditions is not yet approved, and you can ask to consolidate those. If, while your case is pending, or after your card is issued, you move, you should always submit an AR-11 to the USCIS to show that you've moved. It is a regulatory requirement and it's supposed to be done within 10 days, but if you've missed that 10-day window, do it anyway. I know it sounds really kind of like a frivolous requirement, but we have actually seen cases where that is the basis of the USCIS argument later on, trying to deny citizenship to say the AR-11 was not filed. And before you get your card, you should always make sure that the post office has your correct address because it is a secure document. They may not want to deliver without your address being listed with you as a resident. I'm going to go over some frequently asked questions. I haven't gone over every single thing that ever happens in an adjustment of status application because there's such wide variations between the categories, but here's some maybe high questions that a lot of people have. Citizenship. That's always people's next question. How can I do it? What are the requirements? I'll just say there's going to be another webinar on that, so hopefully you'll continue watching this series and I'll give you some more tips and tricks on citizenship in that one. Can I live outside of the United States? If you choose to do that, you are jeopardizing your lawful permanent resident status and you may be seen to have abandoned that status. The rule of thumb is don't be outside of the United States more than 180 consecutive days, but you should also not be outside the United States so often where you're going out for 170 days, coming in for 3 weeks, and then leaving again for another 160 days. That could also be seen as abandoning your residence and that you don't intend to permanently reside in the United States. Definitely there's ways that you can lose your residence, not only through being outside of the United States, but sometimes the government might grant the challenge of your residence just because they think that there was fraud or misrepresentation, or there are facts that they discover afterwards that lead them to believe that you were not eligible at the time. As a lawful permanent resident, you are somebody who could be in removal proceedings where they're trying to deport you from the United States. Sometimes it's for crimes, sometimes it's for immigration fraud, but that is something that can happen for you as a lawful permanent resident. You can only sponsor your own spouse and your children who are unmarried, who are either over 21 or under 21, and it's a different category. But you cannot qualify to petition for your parents or your siblings until you are a citizen. So let me talk a little bit about how CLCMA and the green cards work. So this is the same whether you are doing adjustment of status or you're an immigrant with a green card. We call them all the same thing, but we're going to talk a little bit about how we intersect with this type of application. So most often what we're looking at are cases that have been delayed many years and often double or triple what the processing time has been. And we can file a lawsuit on those cases if we think that the delay is because of a reason for civil rights violation or for discrimination based on race, nationality, or religion. And most often we're challenging it under this program called CARP. And that's the Controlled Application Review and Resolution Program that USCIS has used pretty much in secret, and that's why we are challenging them. And we are able to say that they are not following their own procedure in making applications go through the process and check whether or not they are eligible. And so that is one way that we can challenge a green card case, and we do litigation, and so that is something that we do. We do not file cases generally, but we might do that. Sometimes we have had cases where there have been challenges to the general eligibility like marriage. Like I said, in a lawful permanent resident case, your children have to be unmarried. So we have seen cases where the government has come back to say that if you are now trying to sponsor, let's say, your own spouse, they might go back and try and challenge your lawful permanent residence. That may be something that we defend. But we defend them again in these civil rights areas. They may say that you have fraud or misrepresentation. Again, we have seen cases where they have the questions on the application that are about national security or other things that might be of a concern for terrorism grounds. And for those things, they might say that you lied, that you did not disclose every organization. Quite often we see that the government has either requested that an individual who is applying for adjustment of status at some point since they've been in the US become a confidential informant, or they have been approached by a confidential informant And very often we see that those FBI interviews that our criminal section might do are also related to some of the applications that we have for adjustment of status and sometimes citizenship. This stands for the terrorism-related inadmissibility grounds. And what that means is there are certain things that have happened for groups and associations and maybe military training for countries or military organizations or other organizations that the U.S. has now designated as terror organizations or helping terror organizations. So that can sometimes be a reason, and we will quite often have those cases where we screen them to see if they fit our profile. So now I'm going to tell you a little bit about the difference between what a general immigration attorney does and what we do at CLCMA that we call impact litigation. So immigration is broad, it's complex. If you see the wide variety of webinars that we have, you can see that I'm not even touching on everything. But what we do is impact litigation, and it requires that we know a lot of the laws that are general. Even though we may not take on somebody's general marriage-based application or general citizenship application, we still need to know all those rules so that we can see when things have gone wrong. And most immigration attorneys only do those petition-based cases. They do not litigate cases. So we take on these cases knowing that these are going to be impact litigation cases and they're going to be time intensive. So we are very selective. When we look at our intakes, we may get hundreds of intakes in a year. We're going to take those in, we're going to have that consultation, and then we're going to internally discuss it and make a recommendation to our board of directors, because they do approve every case that we have, or they will reject it saying that we don't have the resources or they don't think it's within our scope. If they approve it, that becomes one of our impact litigation cases. And when we take it on for the long haul. So we do look for those litigation and administrative cases that will help fight against discrimination and injustice by the U.S. government. We're looking for those cases where there's been a violation of the U.S. Constitution or a civil rights violation based on race, religion, or country of nationality. A lot of times those involve complex legal questions related to national security, and that's included in all of our sections that we do. So all the litigation from criminal to general civil litigation and through immigration. And we also have a nonprofit practice group that helps some of our nonprofit groups, and we have a nonprofit practice group that helps those organizations to be in compliance so that they don't jeopardize their nonprofit status. We know that we can only accept a few cases, but we do know that we will also vigorously accept those cases and represent those matters. But we know that when we accept those cases, we will vigorously represent those matters and make a broad community impact. So sometimes I get those general immigration questions, and I do still give those consultations because I want people to know that they're being heard and that they have the opportunity to at least see if they will fit within our scope of services. So sometimes they're coming to me not even knowing if they need an attorney. And so I will walk them through that. Is it just filling out forms? My relative did this without an attorney. Do I really need one? It costs so much. My case is simple, but as I've told you, there are things that you would think are simple, filling out a change of address, checking one of the boxes that you think you're answering right, and the government thinks the answer should be different. So that is something that we explore when we do those consultations. We want to know, is this really something that can be an impact litigation, or is it a general immigration case? If it's a general immigration case and I'm not able to recommend you to the board, what I will do is I will give you those resources. So this is a sample of what I would give, and a lot of times I will give it to you more for your area, but these are the organizations and the ways that I will do that research. But you can do that research for yourself as well. You can do that due diligence and find yourself an attorney, and hopefully one that will help you. So I hope that you have enjoyed this seminar and this webinar on adjustment of status. It's one of my favorite applications. It is one of the ones that we do get the most traction on with our litigation, because there are a lot of things that the government does to delay and deny and use discriminatory reasons to create injustices in the system. And so hopefully you've learned a little bit about what we do and enjoyed it. And again, my name is Kate Brady. I'm the Immigration Department Head here at CLCMA, and I thank you and hope that you will join us for other webinars. And if you do have a question where you think that you have a case that fits within our scope, that you will visit our website at www.clcma.org and fill out an inquiry. And please do watch the other webinars from our other sections that are very exciting and informative, and we hope you are enjoying them. Thank you.